Hello everyone. During this lesson you will learn the basic types of intellectual property categories, what each category covers and the rights a creator has. Moreover, we will talk about the different types of contracts you can make as creators in order to protect your work, to gain money and generally how to use properly your creation for your own benefit. At the same time we will examine the ways you can register and protect your work in national, European and international level. Our aim is that at the end of this course, you can recognize the different types of intellectual property, in which category or categories your creation belongs to and how to manage your business. First of all, let's start with a definition of intellectual property right. Intellectual property is a type of right to intangible property, works of the intellect, and belongs to the broader category of rights that protect the works of the human intellect and is commonly known as intellectual property rights. Intellectual property, now essentially synonymous with what is called copyright in Anglo-American law, gives a time-limited but absolute and exclusive right to the creator of intellectual property, as defined by law, to exercise a range of powers, both economic and moral, nature. Intellectual property pertains to any original creation of the human intellect such as artistic, literary, technical, or scientific creation and referred to the legal rights given to the inventor or creator to protect his/her invention or creation for a certain period of time. These legal rights confer an exclusive right to the inventor, creator, or his/her assignee to fully utilize his/her invention creation for a given period of time. It is very well settled that IP play a vital role in the modern economy. It has also been conclusively established that the intellectual labor associated with the innovation should be given due importance so that public good emanates from it. There has been a quantum jump in research and development costs with an associated jump in investments required for putting the new technology in the marketplace. The stakes of the developers of technology have become very high, and hence, the need to protect the knowledge from unlawful use has become expedient, at least for a period. That would ensure recovery of the R&D and other associated costs and adequate profits for continuous investments in R&D. IPR is a strong tool to protect investments, time, money, effort invested by the inventor-creator of an IP, since it grants the inventor-creator an exclusive right for a certain period of time for use of his invention creation. Thus IPR, in this way, aids the economic development of a country by promoting healthy competition and encouraging industrial development and economic growth. Intellectual property is commonly understood to refer to two distinct branches, each replete with their own set of legislation: industrial property and copyright. Industrial property includes the following: patents for inventions, industrial designs, trademarks, service marks, layout designs of integrated circuits, commercial names and designations, geographical indications and protection against unfair competition. Copyright refers to literary and artistic creations, such as books, music, paintings and sculptures, films and technology-based works. Traditionally then, with regards to IP's relation to the cultural and creative industries, copyright has been recognized as the most relevant branch of IP. Intellectual property refers to an intangible property right which is enjoyed by law after the engagement in intellectual creative conducts, which cover a range of intangible property rights, patent, copyrights, trademark, design right and an indication of the original as mentioned before. European Union regulates the range of the law, including three different interdependent series legislation, primary and secondary legislation, and law in cases. The empty area regulated by individual national members is not in the coverage of EU law. Based on the EU treaties, EU members each have the right to transfer and implement the discretion of EU law. Originally, only patent, trademarks, and industrial designs were protected as industrial property, but now the term intellectual property has a much wider meaning. IPR enhances technology advancement in the following ways: New Delhi, Department of Science and Technology. It provides a mechanism of handling infringement, piracy, and unauthorized use. It provides a pool of information to the general public since all forms of IP are published except in case of trade secrets. IP protection can be sought for a variety of intellectual efforts including patents. Industrial designs relate to features of any shape, configuration, surface pattern, composition of lines and colors apply to an article, whether 2D, e.g., textile, or 3D, e.g., toothbrush. Trademarks relate to any mark, name, or logo under which trade is conducted for any product or service and by which the manufacturer or the service provider is identified. Trademarks can be bought, sold, and licensed. Copyright relates to expression of ideas in material form and includes literary, musical, dramatic, artistic, cinematography work, audio tapes, and computer software. All these will be clearer thought the following examples. First example. The copyright protects the original contribution of the creator that leads to the creation of a specific work. The protection lies in the prohibition of use of the work. Historically, copyright has provided protection for works involving elements of creativity and originality rather than for works of an industrial nature. Although with the introduction of works such as computer programs and databases we have a functional shift of copyright to more useful items. Second example, an innovative invention or production process is protected by a patent. What is protected here is innovation and not originality. Also, as is clear from the obligation to describe the invention and the publicity that form the heart of the patent protection system, the purpose of licensing is not to restrict the use of a particular invention, but to restrict its manufacture. For example, a patent on a machine does not limit the possibility of using it but the possibility of copying its construction. Third example. The trademark protection system secures and protects the particular relationship between a product or service and a particular distinctive feature. Here, protection is not the copying of the trademark logo as much as its association with a particular product or service. The mark itself or the title can be an autonomous object of protection of intellectual property as works of fine arts and work of speech respectively. Through these examples, it is understood that even everything begins from an idea. When this comes true and the creator gives life to this idea, the product that is created can be protected in different ways based on the nature of the product, its use and its innovative character. Now we will see in details the different types of intellectual property. A patent is the granting of a property right by a sovereign authority to an inventor. This grant provides the inventor exclusive rights to the patented process, design, or invention for a designated period in exchange for a comprehensive disclosure of the invention. They are a form of incorporeal right. Registering a patent gives you exclusive rights over your invention for a limited period, normally 20 years. Other people cannot make, use, offer for sale, sell or import a product or a process based on your patented invention. You can give someone else temporary permission to use the invention through a patent license agreement or sell the patent to someone else. You cannot renew a patent after it expires. What a patent protects? You may use a patent to protect your technical inventions such as new products or services which involve an inventive step and have industrial application. How you register a patent. If you need protection in only one European country, you can register a patent at national level. Each country has set its own procedures in order to register a patent. The procedure is sometimes complex, but the UPO describes in detail every step that must be done. You can find the Greek procedure in the relevant Greek website and also for the Italian procedure in the website of the Italian Patent and Trademark Office. For European-wide protection, you can register a European patent with the European Patent Office. You can find the procedure in detail in the relevant section of UPO's website. A European patent also needs to be validated by the National Patent Office as an external link in each country where protection is required. Depending on the countries, you may have to provide translations or pay fees by a certain date. If you wish to have protection at international level, you need to contact the World Intellectual Property Organization. If interested for this procedure, you can visit WIPO website where you can find in details the whole procedure and the prerequisites in order to achieve the international protection. What is trademark in simple words? The term trademark refers to a recognizable insignia, phrase, word, or symbol that denotes a specific product and legally differentiates it from all other products of its kind. A trademark exclusively identifies a product as belonging to a specific company and recognizes the company's ownership of the brand. What a trademark protects. Registering a trademark gives you exclusive rights over distinctive signs, such as names, logos, colors, images, patterns, shapes, packaging of goods, or sounds which identify your product and distinguish your goods or services from others. How long can you protect your trademark for? In most countries, trademark protection lasts 10 years, starting from the date of your trademark application. You can then renew your trademark protection for 10 years each time, for as long as you like. When you own a trademark, you can sell it to someone else or give them permission to use it through a trademark licensing agreement. How you register a trademark. If you only trade in one EU country, you will only need protection in that country. In this case, you can register a trademark at national level. The procedure is similar to the one concerning the patents and can be done through the same websites. If you only trade, for example, in Italy and Greece, you should register your trade in these two countries. This gives you protection in these two countries alone. If you need protection in all EU countries, you should register your trademark with the European Union Intellectual Property Office. The EU IPO website also features a digital office, where you can learn more about trademarks in the EU, and get personalized support on intellectual property. For international protection, in particular if you trade outside the EU, you can register your trademark with the World Intellectual Property. Copyright is a legal means of protecting an author's work. It is a type of intellectual property that provides exclusive publication, distribution, and usage rights for the author. Many different types of content can be protected by copyright. Examples include books, poems, plays, songs, films, and artwork. When you create an original literary, scientific, and artistic work, such as poems, articles, films, songs, or sculptures, you are protected by copyright. Nobody apart from you has the right to make a work public or reproduce it. In EU countries, copyright protects your intellectual property until 70 years after your death, or 70 years after the death of the last surviving author in the case of a work of joint authorship. Outside of the EU, in any country which signed the Berne Convention, the duration of copyright protection can vary, but it lasts until at least 50 years after the author's death. If you want to prove the existence of your work at a certain point of time, a registration can be useful. The question that may arise in this type of intellectual property is how someone can obtain copyright protection. If you create literary, scientific, and artistic work, you automatically have copyright protection, which starts from the moment you create your work, so you don't need to go through any formal application process. However, you may need to advise other people that you are the author of that work. You can attach a copyright notice to your work, such as the "All Rights Reserved" text or the symbol, together with the year the work was created. Copyright protection grants you the following exclusive rights. Economic rights, guaranteeing you have control over your work and remuneration for its use through selling or licensing. Moral rights, usually protecting your rights to claim authorship and to refuse a modification of your work. As it is clear, copyrights can be divided into copyrights that are economic rights, which protect the economic value of a copyright work, and moral rights, which protect the moral interests of the author. Moral rights are rights which allow the author of a copyright work to prevent his or her work from being altered or made public without the author's permission, and these rights are inalienable and particular to the author. Copyrights that are economic rights are divided into rights corresponding to the various usage forms of copyright works. There are cases in newer types of media where more than one rights category is involved compositely. For instance, in music distribution over the internet, the right of reproduction is exercised for the uploading of music to a server, and the right of public transmission, which includes the right of making a work transmittable, is exercised for the acts of uploading and transmission associated with transmitting a work upon request from an end user. The moral rights are, for example, the author's or creator's special right, which includes the right to paternity and the right to integrity. The right to paternity is the right of the author to claim authorship over his work and have it attributed to him. On the other hand, the right to integrity permits the author to restrain or claim damages in the event of any distortion, mutilation, modification, or any other untoward act done to his work. However, it is essential that such act in question should prejudice the honor and reputation of the creator or author, and such act should be done before the expiry of the term of copyright in the work. Though initially intended to protect only literary works, the concept of moral rights was later extended to artistic, musical, dramatic, and cinematograph films as well. For example, this picture is covered by copyright. Protection area does not refer to the procedure of making the bread, but the result of the work that has been done in order to picture this image. If we want to use this picture, we must ask for the permission of the creator or the owner, or otherwise we are obliged to refer to the creator of the obtainer of the rights of this picture, which in this case is typosed. Trade secrets are intellectual property rights on confidential information which may be sold or licensed. In general, to qualify as a trade secret, the information must b. commercially valuable because it is secret, be known only to a limited group of persons. Trade secrets can include a vast amount of information and know-how that is not protectable or cannot be protected properly through patents, such as early-stage inventions, manufacturing processes, lists of suppliers and clients. Information protected by trade secrets can be strategic for the long term, like recipes or chemical compounds, or for shorter periods, such as the results of a marketing study, a brand name, price and date of launching of a new product, or the price offered in a bidding procedure. If you possess valuable information on technology or on any other aspect of your business, you can protect it as a trade secret if the following conditions are met. The information is not known either by the public at large or by the experts of the sector in question. The information has commercial value. You have taken steps to keep the information secret. For example, you keep it in safe storage and you have signed non-disclosure agreements with anyone that has access to it or with whom you have shared the information. The fact that you have a trade secret does not mean that you have exclusive rights over the information in question. If someone else develops the same information, he or she can use it freely. However, you are protected against dishonest behavior. For example, if someone accesses the documents related to your secret information without your authorization, copies them for their personal use, or gives them to someone else, you are also protected if someone breaches a non-disclosure agreement and makes the information available to someone else. In situations of dishonest behavior, you are entitled to damages and other remedies. For example, a court order can prohibit the use or further disclosure of the trade secret by the person who had acquired, used, or disclosed the trade secret unlawfully. Design protection guarantees you the exclusive right to use a design, which includes making, offering, putting on the market, importing, exporting, or using the product in which your design is incorporated or to which it is applied. What design protection covers? You can request design protection for the appearance of the whole or a part of your product. Your design results from the features of the lines, contours, colors, shape, texture, and/or materials of your product. Design protection guarantees you the exclusive right to use a design, which includes making, offering, putting on the market, importing, exporting, or using the product in which your design is incorporated or to which it is applied. If you give your authorization, third parties can use your design in their products. Concerning the duration of the protection at national level, it depends on the national legal framework. In European level usual it is 5 years. If you create a new design which meets the requirements of novelty and individual character, then you may need to register it. If you only need to protect your design in one EU country, you should register the design at the relevant national IP office. Unfortunately, there is not a website for all the national IP offices, since this service sometimes is under the control of the relevant ministry. You can find all the contact details in the relevant link. When you do business in more than one EU country, you can protect your design with a registered community design. You will pay €350 for 5 years protection, and you have to register your design with the European Union Intellectual Property Rights Office. If you only need protection for your design at EU level for a short period of time, such as 3 years, you can choose not to register your design and use an unregistered community design instead. You don't need to register or pay any fees. A UCD protects your design from the moment of public disclosure. After it expires, you cannot renew it. In addition to the design protection, designs are also eligible for protection under copyright law if they fulfill the protection requirements for both originality for copyright and novelty and individual character for design rights. If you create an original design, your copyright protection starts immediately from the moment of the work's creation, without the need for any registration of your design. In these pictures we can see examples of dress creations by Alexander McQueen that are protected under the provision of intellectual property law. Differences between patents, copyrights, trademarks, trade dress, and trade secrets. Intellectual property is generally intangible property resulting from some degree of creation. The various forms of IP are distinct and offer different protections under patent, copyright, trademark, trade dress, trade secret, and other related laws. In the following table we can see the differences between different types of intellectual property forms. Patent. A patent gives the inventor exclusive rights in the invention for a period of time, so that he or she can profit from the invention before the right to exploit it is available to the general public. Patents can be granted for plants and other life forms, designs of manufactured products, machines, processes, and combinations of matter. A patent protects inventions or discoveries and grants the patent holder the exclusive right to make, use, offer for sale, and sell inventions, including new and useful processes, machines, certain designs, and certain varieties of plants, for a period of 20 years. Copyright. A copyright prevents others from copying, making derivative works of, performing, distributing, or selling copies or counterfeits of original works of authorship, such as music, lyrics, books, plays, poems, paintings, sculpture, photographs, architectural designs, and software. The creator of the work is generally considered to be the author of the work and is the owner of the copyright. An author of a work need not register the work with the U.S. Copyright Office to be protectable under copyright law. The work is generally protectable for the life of author plus 70 years. Trademarks. A trademark, service mark, or logo prevents others in the marketplace from using a confusingly similar name, symbol, or device to indicate the source of its goods or services. A trademark protects words, phrases, symbols, or designs identifying the source of the goods or services of one party and distinguishing them from those of others. Trademarks are generally protectable as long as they are used in commerce to distinctively indicate the source of the goods or service. Trade dress protection is similar to trademarks and can be used to identify and promote the non-functional aspects of a product or service. For example, the shape, color, and design of a product or its packaging can be trade dress. Likewise, the decor and color scheme of a restaurant or store also can be trade dress. Trade dress is generally protectable as long as it is distinctive and used in commerce to indicate the source of the goods or service. One of the most important points concerning intellectual property and the creator of a work is how the creator can commercialize his or her work. This can be done in several ways. The first is to sell its works. In this case, the creator loses all the rights he/she has over his or her creation. But if a creator wishes to obtain the rights of his or her work, but at the same time he/she wants to commercialize the work, this can be done through intellectual property assignment agreements and licenses. Intellectual property can be just as valuable as, or even more valuable than, tangible property. Many companies make money exclusively through marketing products based on intellectual property rights. That's why it is so important to protect your intellectual property through patents, trademarks, copyrights, and other legal devices that keep your intellectual property safe. However, once you have secured your intellectual property rights, it is sometimes more convenient or valuable to let someone else use them in exchange for a fee. Which is why intellectual property agreements and intellectual property contracts exist. These documents are complex agreements that determine the manner in which third parties can use your intellectual property. Intellectual property agreements and intellectual property contracts require careful negotiation, and owners of intellectual property should conduct these negotiations with the support of an experienced intellectual property lawyer. Because you have the right to confer your intellectual property rights to other parties, intellectual property agreements can take one of two basic forms: assignment agreements and IP license agreements. Let's start with assignment agreements. Under an intellectual property assignment agreement, you permanently transfer some or all IP rights to the assignee in exchange for a specified sum. Essentially, you sell the rights to a third party the same way that you could sell physical property for a permanent transfer. Generally, you relinquish all control, involvement, and claim on the intellectual property rights transferred. As we said before, in other words, this case can take place when a creator wants, for example, to sell its work to someone. At the time when I buy a picture, the creator loses any right over the creation. But the law does not predict only cases when the creator wants to sell his creation. Under an intellectual property licensing agreement, you retain ownership of your patent, copyright, or trademark, but you give another party permission to use some or all of your intellectual property rights for a specific amount of time for a fee or royalty. These intellectual property contracts typically specify termination dates and procedures. There are several types of intellectual property licenses embodied in a typical intellectual property agreement. The following three are the most common. Exclusive license. As creator and owner of the rights over the work, you agree not to grant any other licenses of the invention and rights concerned, as well as not to use the technology yourself. This is to say, that you rent your creation for a certain period of time to someone else, and during this certain period you lose any right. Sole license. In this case, you agree not to grant any other licenses of the invention and rights concerned, but you can use such rights yourself. This is to say, that you rent your creation for a certain period of time to someone else, and during this certain period you lose any right to give the rights to anyone else. But you, as the creator and owner of the fundamental rights, you can use the work for yourself. Non-exclusive license. In this scenario, The creator agrees to give the licensee certain rights, but also reserve the right to grant licenses of the invention and rights concerned to third parties or to use them yourself. These law predictions are not so strict, and you can also combine elements of these three types of intellectual property agreements, such as by giving an intellectual property license for exclusive rights in certain geographic areas. Which is better, an intellectual property assignment agreement or an intellectual property license? The reality is that there are pros and cons to each choice, depending on your needs and interests. Most of the time, IP holders want to maintain control of their IP, and they choose intellectual property licensing. This is advantageous because you can determine the manner in which your IP is used and change partners if a partnership isn't advantageous. Also, intellectual property licensing allows you to produce a steady income from your IP over a particular time period and possibly confer the same rights to multiple users. Intellectual property assignment agreements can also have its advantages, however. If you assign intellectual property to a third party, you no longer have any responsibility towards the product. That means you cannot generally be sued for problems relating to your IP, and you are not responsible for any maintenance fees. Intellectual property assignment is generally more appropriate when you are selling your business or leaving the field entirely. Finally, in this last slide you can see the differences among the three levels of IP protection: national, European and international. Several general principles are important for effective protection of intellectual property rights in the EU. First, it is important to have an overall strategy to protect your IP. Second, IP may be protected differently in the EU than separately in each member state according to national law. Third, rights must be registered and enforced in the EU, both under local and European laws. For example, your trademark, design, and patent registrations, since they are protected under national law, will not be protected in the EU market without further registrations. Most copyrighted works created in a member state of EU will not be automatically protected in the EU from the moment of creation or publication according to EU and international agreements. However, the extension of protection may vary according to the laws of each EU member state. Protection against unauthorized use will vary depending on the national laws of each country. Obtaining patent grants in the EU is based on a first-to-file basis. Similarly, most trademark and design rights are based on a first-to-file registration system, so you should consider how to obtain patent, design, or trademark protection before introducing your products or services to the EU market. For a national registration, you have to follow each country's national law procedures, which are described in every national platform. In your book you can find the website addresses in order to find more information. Keep in mind that the national prescription protects you only for the country you made the registration. Concerning the European level, you can register your work in order to be protected through the European platform. The beneficiary may apply electronically to EU IPO for a community trademark by selecting the community procedure. The cost of the fee covered by the online application for a class is €850. The fee for the second class of goods and services is €50 and the fee for the third and each additional class is €150 per class. Once the application has been lodged, EU IPO processes the mark to verify that it can actually be registered. The whole process includes various stages. Upon publication of the registration, a certificate is issued. Given the principle of temporal priority and exclusivity with the registration of the mark, the proprietor is entitled to prohibit the sale to any third party of goods or services within the European Union with a mark or sign identical with or resembling it and creates a risk of confusion. The registration is valid for 10 years, where it can then be renewed. The process of electronic trademark registration is done step by step according to the instructions given in the EU IPO form. The European trademark registration process has accelerated considerably in recent years. However, the European Trademark Office's overarching goal is to complete the whole trademark registration process within 26 weeks, which is extremely difficult, considering that it provides protection automatically and simultaneously in all member states of the European Union. Trademark registration at European level takes place simultaneously in all European member states, without the possibility of selecting specific European countries. There is a single trademark registration fee which is specific and stable, and European trademark protection protects the beneficiary throughout the European territory directly. For an international protection, a prerequisite for trademark registration at international level is its previous registration at national or community level. The process is done electronically through a form of the World Intellectual Property Organization. The WIPO, World Intellectual Property Organization process through the Madrid system provides for the registration of trademarks in specific countries. The basic fee for applying for an international trademark is 653 Swiss francs, approx. 572 euros for a black and white mark, or 903 Swiss francs, approx. 791 euros for a color mark, plus additional costs depending on which country you want to protect your trademark and how many categories of goods and services will be covered by your registration. International trademark registration is done simultaneously for many countries or one by one. The global trademark registration process is carried out by submitting a request to WIPO, World Intellectual Property Organization, and requires a lot of experience, as the companies involved are many and often raise objections. The international trademark registration process requires the prior submission of a national or European trademark application, otherwise it cannot proceed. Trademark registration is a complex process and requires careful handling, as a misstatement in a service can trigger a process of objections from strong global firms. For the above reason, before starting the trademark process, contact an experienced trademark lawyer. I hope that during this course, I managed to clarify the basic types of intellectual property categories, what its category covers and the rights a creator has, the different types of contracts you can make as creators in order to protect your work, to gain money, and generally how to use properly your creation for your own benefit. We examined the ways you can register and protect your work in national, European and international level. Now, I hope you can recognize the different types of intellectual property, in which category or categories your creation belongs to, and how to manage your business. Thank you.